A desk appearance ticket, often called a DAT, is a directive for a person who is arrested in New York to appear in court on a later date. The DAT return date is usually 6 to 12 weeks after the initial arrest. If a person is issued a DAT, he or she will be required to appear in court for arraignment, which is the first step in a criminal prosecution. Failure to appear on the date of the DAT will result in a bench warrant issued by a judge. On the DAT arraignment date, a criminal complaint is filed listing the charges, and certain notices will be provided to the defense. It is not unusual for a DAT to be resolved at the arraignment. However, a prosecutor may want time to investigate cases that involve a complaining witness and may not offer a resolution on the DAT date. Receiving a DAT is preferable to being held for arraignment because it allows a person to avoid spending up to 24 hours in a holding cell. In addition, a person who receives a DAT has the advantage of hiring a criminal defense attorney prior to arraignment. The attorney can investigate, assess the case, and negotiate with the prosecutor before arraignment. This increases the likelihood that a case may be resolved favorably. Whether or not a person is issued a DAT depends, 1. on the nature of the alleged crime, 2. if a person has valid government-issued ID, and 3. any prior arrest record and/or criminal history and bench warrant history. In New York, DATs are often issued for misdemeanor crimes like assault in the 3rd degree, petty larceny, criminal possession of a controlled substance in the 7th degree, criminal mischief in the 4th degree, possession of marijuana, and theft of services. However, a DAT is rarely issued if the crime involves domestic violence or if a person has an open warrant or multiple criminal convictions. 2 possible resolutions at the DAT arraignment include a plea bargain from a criminal to non-criminal offense or an ACD. Disorderly conduct is a violation and not a crime and does not give a person a criminal record. An ACD, or adjournment in contemplation of dismissal, results in the dismissal and sealing of charges after 6 or 12 months, depending on the crimes charged, so long as its terms are fulfilled and the person is not rearrested over the period. In addition, the proposed outcome may include terms like restitution, community service, or a program where appropriate. Whether or not an offer of an ACD or disorderly conduct is made on the DAT date depends on a variety of factors, including the allegations, prior criminal history, and prior contacts with law enforcement. If the case is not resolved at arraignment, another court appearance will be scheduled for the prosecutor to obtain a supporting deposition, if one is needed, for the defense to file motions or even for a trial. The bottom line is that when a DAT is issued, the sooner a person seeks representation, the better. As a former prosecutor and current criminal defense attorney in New York, Andrew has handled thousands of desk appearance tickets for every crime imaginable. For more information, visit the website of Andrew M. Stengel, stengellaw.com, or send an email to info@stengellaw.com.